Welcome, welcome, welcome. One and only to the one and all. Alright, so I'm just gonna go straight into it today. No intros necessary. Whisper of disquiet. A courtroom drama unveiled. The air in the courtroom hung heavy, thick with the tension of a high-stakes legal battle. It was November 15, 2023, and the very foundations of justice seemed to tremble under the weight of accusations. We, the defense, had just filed our Miranda of law in support of motion for a mistrial in case of the people of the state of New York versus Donald J. Trump, of course. A document not merely full of legal arguments, but a desperate plea for fairness in what felt like an incredibly biased arena. The core of our motion wasn't just about legal technicalities. It was about the very spirit of impartiality, that should govern our courts. At the heart of the concern was the principal law clerk, a figure who, by all accounts, should embody neutrality. Yet, her actions painted a different picture. We presented evidence of her partisan contributions, significant sums flowing to Democratic causes, far exceeding the $500 limit set by judicial ethics. It wasn't just money, it was the receipts. Organizations vocally aligned with the Attorney General, Letitia James, whose very public stance against my clients made these contributions particularly galling. It felt as though the lines between judicial staff and political advocacy had blurred beyond recognition. The judge's response to our concerns was equally alarming. A $10,000 fine was levied against us simply for pointing out the alleged partisan leaning of his clerk. And then, a second gag order was issued. A chilling decree that silenced even the counsel from speaking about the clerk's public conduct. It was as if a curtain had been drawn, attempting to obscure what we believed to be a glaring conflict of interest. Will you cut it out? Oh, man. Attempting to obscure what we believed to be that glaring conflict of interest. Correct. Okay. This wasn't merely an appearance of impropriety. It was perceived active suppression of our right to bring legitimate concerns to light. Beyond the clerk's actions, the very conduct of the court itself became a focal point of our mistrial motion. This was a complex commercial case, one that, in our view, cried out for the expertise of the commercial division. Yet, our request for transfer was denied, leaving us to navigate the intricate financial details in a setting we felt was, ill-equipped for such complexities. Then came the trial schedule. Oh, a timeline so aggressively compressed, it felt designed to hobble the defense. The Attorney General proposed start date of October 2nd of 2023? Yes, was adopted by the court with seemingly little consideration for the sheer volume of the evidence we, needed to sift through. Millions of pages, dozens of witnesses, while the prosecution had enjoyed a 3-year head start conducting an exhaustive investigation. We were given a mere fraction of that time to prepare. Our pleas for adjournment were met with dismissive wave, the court declaring no need for extensive disclosure. It felt like a race, where one participant had a rocket, and the other was given a pair of roller skates. Oh, I forgot to leave out, they throw a stick in there. Threw a stick out there. Oh, man. Perhaps most egregious were the evidentiary rulings. Like, time and again, the court allowed the Attorney General to introduce time-barred evidence, historical data, and events that the First Department had explicitly ruled inadmissible under the flimsy pretext that it related to potential injunctive release. It was a legal maneuver that felt akin to a magician's trick, distracting from the clear directive of the higher court. Hearsay testimony, often without clear designation of its target, was also permitted, further muddying the water of due process, and we sought to preclude expert testimony that appeared designed to fill the prosecution's, evidentiary gaps, rather than the complementary existing facts. Our motion was denied. It seemed as if every turn led to a ruling that favored the prosecution in this foul jury, leaving us to wonder if the scales of justice had, been irrevocably tipped. This legal battle was more than just a fight over finances. It was a deeply personal struggle against what we perceived as an unfair process. We were, in essence, battling for every soul of the judicial system, demanding the principles of neutrality and due process to be upheld, even in the most politically charged of environments. This question remained. In the face of such perceived bias, could true justice ever prevail? That is the end of that chapter. I'm going to jump around a little bit, so that's kind of how my mind works. Try and stay with me here. The sword and the shield of power. Presidential immunity in the crosshairs. The legal landscape surrounding a former president, particularly one embroiled in charges of conspiracy to subvert an election, is a terrarium fraught with unprecedented questions. At the heart of this, modern legal drama lies the intricate and fiercely debated concept of presidential immunity from criminal prosecution. Imagine the highest court in the land, the Supreme Court of the United States, grappling with a question that has no direct historical precedent. In December 2023, the government, through special counsel Jack Smith's office, had urgently sought and writ a certiorari, I might have butchered that, CERTIORARI, before judgment in the U.S. states versus Trump. This was a plea to the court to directly address the former president's extraordinary claim of absolute immunity from a federal criminal prosecution for actions taken while in office. Hoping to resolve this pivotal issue with, the utmost speed, the error must have been correct, with anticipation of the Supreme Court weighed with this request. Ultimately, they denied the review at the immediate juncture. This denial, for some, signaled a reluctant, from its dive into such an uncharted water, prematurely, perhaps, preferring the issue to be ripened through the normal appellate process. Indeed, by the early 2024, the D.C. Circuit Court of Appeals had already unanimously affirmed the denial of the immunity in thorough opinion, explicitly rejecting the former president's arguments. The government's position was unwavering. The former president simply couldn't demonstrate a requisite likelihood that the Supreme Court would overturn the lower court's judgment and validate such an extraordinary claim. They argued with conviction that the serious harm to this government and the public of postponing the resolution of this criminal charge far outweighed any personal equity for the former president could assert. The public interest, they stressed, was at its zenith. When a former president is accused of conspiring to undermine the very electoral process and cling to power. The nation, they instead had a compelling interest in seeing the charges brought to trial. The absence of the historical and scholarly support for this case, sweeping claim of absolute immunity was a reoccurring theme in the government's arguments. No found era suggestion. No former president making such a claim. No scholarly commentary positioning such immunity. This lack of precedent underscored and unprecedented nature of the former president's legal stance. However, the government also presented an alternative. If the Supreme Court did feel the immunity claim warranted immediate review, they respectfully requested that it treat the application as a petition for a writ of certiorari granted, and set the case for expedited briefing and argument. Their proposed schedule would have allowed the arguments in March 24 mirroring the court's treatment for other cases deemed nationally important. The aim was clear: to resolve the threshold immunity issue and promptly as possible this term, ensuring that if immunity was rejected, a timely and fair trial can be, beginning within the minimal addition delay. This particular legal saga isn't just about abstract legal principles, it's intricately woven into the broader fabric of high-profile cases involving, former presidents. For instance, the discussion of a final report and the 11th Circuit points to the separate yet interconnected legal battle surrounding classified documents. In that case, likely United States versus Trump, Noata, and De Oliveira. There was a period where the district court judge issued a temporary injunction, preventing Attorney General Garland, Special Counsel Smith, and their teams from releasing or sharing the transmitted files, the final report, or any drafts of such report outside the Department of Justice. This was to preserve the status quo. Pending resolution of emergency motion in the 11th Circuit, the very mention of defendants Nata and De Oliveira confirms this link, as they were co-defendants with the former president in the classified documents case. The intertwining of the legal threads paints a vivid picture of a former president simultaneously battling charges related to the January 6th events and the handling of classified documents, all while pushing the boundaries of executive power and immunity. The legal system, designed to be methodical and deliberate, finds itself under the legal system. Designed to be methodical and deliberate, finds itself under immense pressure to navigate these complex and politically charged waters. With the very definition of presidential power hanging in the balance, the nation watches, breath held, as the legal dance between sword and prosecution and shield of immunity unfolds. What will happen next? The veil of secrecy, transparency, justice in high-stakes cases in the hallowed halls of justice, a fundamental principle stands: public access to criminal court proceedings. Lucky me. This isn't merely a courtesy, it's a deeply integrated constitutional right. If you don't know, now you know. So, stemming from the First Amendment, the idea is simply yet profoundly: transparency breeds trust. A public scrutiny ensures fairness. As the Supreme Court has articulated, a presumption of openness inheres in the very nature of criminal trial under systems of justice.